So welcome everyone. Thank you for joining us. We appreciate you taking the time to complete this training, and we hope it's very helpful to you. I will introduce that this will be as a HIPAA training for area agencies on aging and our partners, specifically, those involved in our efforts to deliver programming to clients in the field and who may come into contact with personal information. As part of a grant that MA4 has statewide work, we have developed an MA4 network, and so individuals involved in delivering programming through that network are required to complete a HIPAA training once a year, and this will count towards that contractual requirement. We will issue certificates for those who complete the training, and completion will include that we monitor active time participating or viewing the webinar, and then we will be administering quizzes throughout the training, and then monitor that participants receive at least 80% correct. So that will count towards completion of the training, and that's how we will determine completion, and then we will issue certificates through your area agency on aging in several weeks after the completion of this HIPAA training. We will offer this twice per year, so we'll try to offer another one in the fall to make it easier for you and your area agency on aging partners to maintain HIPAA compliance in the network. We are happy to have Scotty Allen providing this HIPAA training for us today. Scotty is the general counsel for the Missouri Veterans Commission in Jefferson City. He has 20 years of legal experience, previous jobs with the Missouri Attorney General's Office and the Department of Social Services. He's a native of Springfield, Missouri, and a graduate of Southwest Missouri State University and the Washington University School of Law in St. Louis. He's licensed to practice in both Illinois and Missouri, as well as the military courts of the United States. He and his wife, Jody, are proud parents of 4 children, Jacob, Billy, Alexandra, and Stella. So we welcome Scotty and thank him for taking the time to offer this training to us today. He will, before I hand it over to him, just a quick overview. He will be speaking to us today about the intricacies of confidentiality law with an emphasis on the Health Insurance Portability and Accountability Act of 1996, otherwise known as HIPAA. And at the end of the presentation, you should be able to identify common HIPAA compliance issues and the appropriate response to each. So I will now pass this off to Scotty, and again, thank him for his time. Oh, one more note. We will be taking, at the end of his presentation, we will take questions. I will be monitoring questions in the chat box. So if you have a question, that's where you will submit questions, and then I will post them to Scotty. We will do about 20 minutes of Q&A after the presentation. Thank you, Scotty. It's all you.
Hi, everyone. All right, there we go. Okay. Hi, once again, I'm Scotty Allen. I'm the General Counsel for the Missouri Veterans Commission. I've been dealing with HIPAA pretty much from the beginning. I started practicing law in 2000, and HIPAA really kind of came online in 2003. So pretty much immediately I got stuck having to deal with this law all the time, and I've kind of gone through every phase of dealing with HIPAA. In the beginning, I avoided it, didn't want anything to do with it, and then I moved into a job where I had to interact with it periodically, but really it was more of a impediment to the main part of my job at that particular point. So I went into this phase of hating it, and then I got promoted to privacy officer at the Department of Social Services, and HIPAA became kind of the focal point of everything that I did. And as I dug deeper and deeper into it, I actually came to enjoy it quite a bit. So it's gone through all the phases with me in terms of how I feel about it emotionally. But it's really a fairly user-friendly law, and if you break it down to its core, it's really very common sense. If you forget everything else that I say to you today, just remember this. HIPAA in a nutshell is very simple. It is, don't share people's health information without either getting their consent to do it or having some legal reason for doing it. This presentation is all about the legal reasons that you can share people's health information without their consent. So always remember, if you get their consent, you're never wrong to do that. You'll never hear a HIPAA practitioner, certainly not me, tell you, oh no, don't get their consent. You're never wrong to do that. So just kind of keep that in mind. That is, in a nutshell, what HIPAA is really all about. And to me, that's common sense. I think that's what everybody kind of expects when it comes to their health information. You know, when you go to the doctor, you expect the doctor to keep that confidential and not share it with people needlessly. So to me, it's a very common sense law. But without further ado, jump right into a kind of an overview roadmap of where we're going to go today. I'll introduce you to the law, talk about how it protects people's information, when you can share it, under what circumstances, what's a breach, what do you need to do when one of those occurs, and then we'll wrap it up with some participant rights that people have under HIPAA as well. So what is HIPAA? If you actually look at the statute for HIPAA, it's a very short, I think if my memory is correct, it's like 2 to 3 pages long. Basically Congress punts in the law. They basically say there will be a law called HIPAA. Here's the basic framework, and DHSS, you have to figure out how this works. And so the Department of Health and Human Services have implemented regulations that number, I believe, somewhere around 286 pages. And those are represented here on the screen in Part 160, Part 162, and Part 164. That kind of fleshes out what the law is all about. But really, if you read through that, which I realize most of you won't, but someone like myself who has read through it, it really opens up a whole lot of other questions. And so then you have to turn to what is called the Federal Registry. And in the Federal Registry, that is where the agency goes into excruciating detail, laying out what they mean with the various provisions that they've put into the regulations. The Federal Registry numbers around, I think it's around 3,000 pages of, like I said, excruciating detail, laying out what all this stuff means. And so really, if you want to be an expert at HIPAA, that's where you need to go. You need to read the Federal Registry. And like I said, only a nerd like myself would read through something like that. But without further ado, let's jump right into what the 3 parts are all about. Part 160 is all kind of the administrative section of the law. That gives you all the definitions of terms. It gives you compliance requirements, how the feds can come in and investigate you, what are the penalties in the event that they find that you violated the law, what your hearing rights are if you want to dispute those findings, so on and so forth. Really, about the only reason to go to Part 160 is to see what the definitions are. However, one of the things that's not very user-friendly about the law is, even though the definition section is found in Part 160, each subpart of the law also has its own definition section. So it's, like I said, not very user-friendly, because to ensure you've got the true meaning of what the terms are, you have to check both. And so it's a lot of flipping back and forth, back and forth. Thank goodness that you can get this stuff online, so you can just open up 2 websites and go back and forth between the 2. Part 162, there's really no reason to get into because that basically just kind of sets the codes that are used for the electronic communications that take place between healthcare providers and healthcare insurers. All of that is set in stone. The only person that the law authorizes to change that is the Secretary of Health and Human Services. So that is a done deal. They do change it periodically, but it's pretty much set in stone and no one can mess with it. And it basically is what it is. So there's really no reason to go looking at it. Part 164, that's all your security and your privacy requirements. And this is the part of the law that applies to pretty much everyone who touches health information. And so this is where we're going to focus our attention today. So you can basically break down Part 164 into 2 sections. You've got the security rules and the privacy rules. Got a little joke there on the screen for those who come from my generation, a little breaking down there. Oh, I got to do what I can. This is a very dry material, so bear with me on my bad jokes here. But the security rules, that's pretty much all the stuff that your IT folks are taking care of. That's all the malware that's in place, what kind of, IT security measures need to be implemented to protect the people's information. So again, this is an IT function that really the techie folks take care of. Privacy rules, though, that is what applies to folks like you and I in terms of how you handle people's information, how you can use it, when you can share it, to whom, those sorts of things. So that's where we're really going to focus our attention today, is the privacy rules of HIPAA. Who does HIPAA apply to? It applies to covered entities. Covered entities are defined as either a health plan or a healthcare clearinghouse or a healthcare provider, like a doctor, a dentist, hospitals, that sort of thing. Healthcare plans include specifically the government plans like Medicaid, Medicare, TRICARE, those sorts of plans. And so anytime you're dealing with those government agencies, you're definitely going to be dealing with HIPAA there as well. What's it mean to be a covered entity? Well, basically you have two statuses, and this is up to the organization to decide what they want to do. They can be either a single covered entity or a hybrid covered entity. And really the best way to think about the covered entity status is to think in terms of bubbles. And so that's why I've given you that picture there on the screen. If you're a single covered entity, you're basically just one big bubble, and the information can freely float around in that bubble. As long as it stays within the bubble, everything is fine. There's no need to get consents to share it within the bubble. That's what most organizations elect to go with, like a doctor's office or a hospital. They'll just declare themselves to be one single covered entity so that they can share the information amongst their staff as they need to. Hybrid covered entity status is like you see there on the screen depicted there with the picture. It's basically two bubbles that are adjoined. What you're doing with the hybrid covered entity status is splitting off the part of your organization that deals with healthcare or health information, and that entity is separate from the remainder of the organization. So you get that membrane there between the two bubbles. And what we're saying by setting that up is the information can freely float around in the part of the organization that is the covered entity, but it cannot go into the other portion of the bubble. This is what our friends at the Department of Health and Senior Services at the state government have elected to do. They've split off parts of their organization to be the covered entities, but they can't share their information with the other parts of DHSS. At Social Services, Medicaid, the Medicaid program is clearly a covered entity. They could have split them off if they wanted to and formed a hybrid covered entity, but since they do so much information sharing amongst divisions, I apologize, I've got a dog freaking out. Since they do so much information sharing amongst their divisions, they said, let's just keep this simple, and they elected to become one big single covered entity. I would imagine in your cases with the area agencies throughout the state, you're probably single covered entities throughout the state because you're probably a fairly small organization, and you do need to share that information freely amongst your staff members. So, like I said, you can set it up as either a single covered entity, or you could have a complex model of a single covered entity like DSS, pardon me, in which you have multiple divisions within the same organization. But as long as the information stays within the bubble, everything's fine. So I point that out to you. It's probably not a problem in your organization, but you might see that in bigger organizations where they'll say, well, we can't share that information with our coworkers in this other division. You might look into whether or not they're a single covered entity or a hybrid. If they're a hybrid, then they're telling you the truth. They truly can't share the information. But if they're a single covered entity, no, they're just misunderstanding the law, and they can share the information within the organization. And the downside of being a single covered entity is everybody is subject to HIPAA, whether or not you deal with health information or not. You are still under the gun, so to speak, of HIPAA. So that's why I elected that picture there on the screen, is everyone is under the hammer of HIPAA if you're a single covered entity. So what does HIPAA protect? It protects protected health information. And again, Sometimes HIPAA is not the most user-friendly law. This is one instance of that, because if you go to the definition section to try to figure out what protected health information is, you actually have to go to 3 different definitions. I've done you the favor of piecing it all together onto one slide here for you so that you don't have to do that. But PHI is basically health information, or individually identifiable health information, pardon me, that is transmitted or maintained electronically or in any other medium or form such as paper. So the reason why they phrased it that way is the whole purpose of HIPAA is eventually they would like the healthcare system to go completely paperless. If you've been to the doctor recently, you know that's not the case. You still have to fill out all those forms every time you go there, even though this is the same doctor you see time and time again. I find that a little annoying myself, but anyway, that was the whole goal, was to go electronic. But someone, thankfully, at the end, somewhere in the process at least, figured out, hey, paper does still exist. So they threw in that 3rd bullet there to make sure that everyone knows that paper is still covered by the law. And periodically, they'll throw in an enforcement case that deals with paper, just to kind of shake us all up and remind us that, hey, paper still is protected. And the most recent one that I can recall that I really jumped out at me, I found it very interesting, was basically a doctor had a falling out with the medical practice that she worked at, and so she quit. And to get back at her, the medical practice just took all the files of all of her patients, boxed them up, and dumped them in her driveway one day. Just kind of a drop off of all these records. Someone reported that to the feds. Let's wonder who. I suspect it was the doctor. And the feds came in and did an investigation, and they fined that medical practice $750,000 for that little stunt. And here's what made the case interesting. There was absolutely no proof that those boxes had been tampered with or gotten into. They were taped shut, but the feds said the mere fact that you exposed it to potential disclosure was bad enough to get you fined. So 750 grand for that little stunt. Pretty interesting case. So what's PHI really? Again, it's health information that is individually identifiable. Can you tell the identity of a specific individual? Let me demonstrate what we mean here. When I first took my job as a privacy officer at DSS, anytime we disclose someone's name associated with the Medicaid program, I said, okay, yep, that's a disclosure of PHI. One day I got bored though at work. I had like 5 minutes left. It was a Friday, no time to get into something serious. I Googled my own name, just out of curiosity. Let's see what's out there on the web for Scotty Allen. And what I found was a few hits dealing with me personally, but I also found several other Scotty Allens who have much more interesting lives than I do, by the way. One of them is a stock car racer. There's a dog sled racer out there named Scotty Allen. And so as I was kind of flipping through these websites, looking at these other Scotty Allens, it dawned on me. I was like, hey, wait a minute. People do have the same name. And so from that point forward, anytime we disclosed just the name associated with the Medicaid program, I would get on Google and say, okay, Jane Smith, Missouri, how many can I turn up? If I turned up several, then I would say that's not a breach, because you don't know which Jane Smith it really is. That's what we mean by individually identifiable. Can you pinpoint it to one person and say, yep, that is the person we're talking about? That's what it means to be individually identifiable. It needs to relate to their past, present, or future health care, or the person's physical or mental well-being. HIPAA covers a lot of things that I don't think would easily or readily come to your mind. It would cover like dental visits. It would cover family therapy, substance abuse counseling, those sorts of things that you wouldn't necessarily think of as healthcare, but they are, because it deals with the person's physical or mental well-being. It also covers information relating to payment for healthcare services, as well as the operation supporting the delivery of treatment or payment. Give you a few examples of things that are PHI that you may not think are. Disclosing the fact that someone rode in an ambulance is PHI. because that is an operation in support of healthcare. Another one that's very common, I see this breach all the time, is the acknowledgement that a woman's pregnant. You know, most people wouldn't think of that as health information, but it really is. That is a medical condition. And so, you know, even though you could easily look upon someone and say, yep, she's pregnant, that's still PHI, even though it is readily apparent to the world by just simply looking at them. So here's some things that PHI can include, obviously names, but it could also be geographic information such as street addresses and counties and zip codes, that sort of thing. Dates of birth, dates of death also. I like to point that one out because I think most people assume when you die, your privacy rights die with you. Actually, it's not the case. They survive you by 50 years under HIPAA. And by the way, that's them cutting us some slack. Up until 2013, it was indefinitely beyond your date of death. So thankfully, they cut that down finally to 50 years. But could be phone numbers, fax numbers, email addresses, Social Security numbers, medical record numbers, pretty much any number that is individually identifiable in the healthcare context is going to be PHI. Okay, we'll pop quiz. I'll skip past that real quick and then we'll come back and talk about it once you all have had the opportunity to respond. Oh, gotcha.
Hi, this is Erica. Just remind everyone about 78% have voted that this is going to be important for us to issue your certification. So I think we'll keep the poll open for a little bit longer. Please vote if you haven't.
By the way, the screen is telling me I can't share my screen until the poll is closed. So I am waiting accordingly.
Scotty, this is Catherine. Just let me know when you'd like to close it and I'll do that and then I'll be back to you.
Okay. How about 90%? Because we're at 87 now.
Yep, sounds good. Thanks.
Yeah, now we're dropping to 86. Oh, back to 87. All right, there we go. Okay, let me get everything out of the way here. There we go. All right, let's back up. Okay, so is it PHI to disclose that 35 people in Jefferson City, Missouri have COVID-19? No, that would not be a disclosure of PHI because there are far more than 35 people in the city of Jefferson City, Missouri. Now, if there were only 35 people in Jeff City, then yeah, it would be. But the point being here, you can't specifically identify who those 35 people are, so therefore it's not PHI. How about number 2 there, disclosing that the woman who resides at 123 Main Street in Jeff City, Missouri is bipolar? That might be a disclosure of PHI. It all depends on how many women live at that address. If there's only one woman that lives at that address, then absolutely that is a disclosure of PHI. If there's more than one woman that resides at that address, then no, it is not. So it gets a little tricky on that one. Number 3 there, disclosing that Espen Jones took NyQuil for her cold last night and feels much better today. That is probably going to be a disclosure of PHI. And the reason why I say probably is because Espen Jones is a pretty rare name, I would assume. If you Googled that one plus Missouri, I suspect you wouldn't turn up but only one person, and that would clearly identify the individual. And then, of course, we know what her condition is. She has a cold, and we know what she did to medicate that condition by taking some NyQuil. So definitely PHI there, I suspect. Again, depending on whether or not Espen Jones is a common name or not. I used to say Jane Jones, and then someone pointed out to me that that's probably a very common name. So yeah, it probably is. So that's why we changed it. Okay, how does HIPAA allow us to share people's information without their consent? Again, knock on wood, as a reminder, you're never wrong to get their consent. But if you need to do it without consent, here's how the law would allow you to do that. First of all, you have this section here that is pretty specific. It has a number of specific instances under which you can share people's protected health information, and really these are probably the reasons that will come up the most frequent. So like public health activities, if you need to share it with DHSS for some sort of like a elder law or elder abuse, allegation, investigation, that sort of thing would be fine. If you needed to share it with a court for some sort of judicial proceeding, that is fine. If you need to share it with the police because they're looking into some sort of criminal allegations, that would be fine as well. If the individual has died and you need to share that information with the coroner, that's fine as well. So those are pretty common scenarios that come up under HIPAA all the time. The other section, though, that covers a lot of the disclosures that are necessary is called the TPO, allowable uses. And TPO stands for treatment, payment, healthcare operations. And under the law, under HIPAA, you can share people's information for these purposes with other entities that need that information for these purposes. So let's get into each one of those specifically. Treatment purposes would be just what it sounds like, providing medical care to the individual. So let's say it's a referral to a doctor or maybe consultation between healthcare providers, that sort of thing is going to be completely fine to share the information with them. Payment purposes would be just what it sounds like. Again, it would be seeking payment for healthcare services that have been rendered. So payment, reimbursement, collection of premiums, those all fall under payment purposes as well. Then healthcare operations is sort of this nebulous category of all these administrative, financial, legal uses of people's health information. Some of the more common things that come up under healthcare operations are like competency and qualification investigations of medical care providers. So let's say they're looking at revoking the license of a nurse or a doctor or some other medical professional, and so they need people's health information to be able to substantiate their case against them. Yeah, you can share it for those purposes. Underwriting activities, so if the health insurance companies need someone's health information to determine the extent of coverage that they're going to provide, that's fine. Some other things, medical reviews, or if you needed to hire an attorney to represent you in a case, that's completely fine to share the information with them as well. Fraud and abuse, detection and compliance programs, that's another very common scenario. So if Medicaid or Medicare ever contacted you and said, we're looking into whether or not this person has been defrauding the program, it's fine to share their information with those folks as well. Now, there is a lot of information sharing that goes on with external partners. I'm sure you're well aware of this. You're probably the external partner of some of the agencies out there that are covered by HIPAA, and that is all permissible under what is known as the business associate exception. Under HIPAA, basically, a business associate is a person, a company, a firm that performs some function on behalf of a covered entity that requires them to either create, receive, maintain, or transmit PHI. Interestingly, a business associate can also be a covered entity themselves, and they often are. So the way this all works is basically between the two organizations, you put into place what is called a business associate agreement. And that is a document that sets forth basically contract provisions that kind of set the ground rules of here's what information we're going to share with you, here's what purpose the disclosure is being made for, and here's how we expect you to protect that information once we do share it with you, and here's what happens whenever there's a breach of that information. So once the parties agree to those provisions and sign up to the agreement, basically, that basically will open the floodgates and will allow you to share whatever information is necessary for that particular task at hand. Now, the requirements of a business associate agreement are set forth in HIPAA. There's the citation there for you, 45 CFR 164-314. However, if you want to just go on the Department of Health and Human Services website, they provide a template, for what they call their recommended BAA agreement. And the reason why I say recommended is anytime the federal government is saying we recommend you use this, they're meaning you need to use this. And so that's what I did at DSS. I just basically went on their website, downloaded the template here, tailored it to fit our organization, and used that. And every time we ever got investigated, the feds never gave me any heartburn over our business associate agreement. So there's the link to it, by the way, if you want to go check it out for yourself. I'd recommend doing that if you're responsible for this sort of thing. Now, under HIPAA, one of the cardinal principles is called the minimum necessary rule, and that's basically, to restate that for you, it's basically, even though you have permission to share people's information, you should only share the minimum necessary to accomplish the task at hand. So a very exaggerated example of that might be, let's say the individual needs healthcare for a broken leg. The fact that they broke their collarbone 25 years earlier probably has absolutely nothing to do with the leg, so no need to share that. Now, one little caveat I'll throw at you when it comes to the minimum necessary rule. The advice I've always given my clients is if a doctor says they need that information, give it to them. They're the professionals. They know how to treat people. It's not our place to be second guessing their judgment as to what information they need or don't need. So that's the one little caveat to the minimum necessary rule. I would say whenever a doctor asks for it, just give it to them. Okay, another little pop quiz that I will sit back and let you all enjoy, and then we'll talk about the answers.
I will just let everyone know we've heard some people have had problems answering the poll if they're in full screen mode. And if you go to window mode, that should help. That should correct the problem if you are having trouble. If you are having trouble, just let us know in the chat, please.
Okay, 90%. All right. Boom. Okay, can we see my screen again? Yeah, there we go. Lights back on. Okay, cool. All right, let's back up and talk about those real quick. Is it a permissible disclosure to disclose client PHI to DHSS personnel investigating an elder abuse hotline call? Yes. Yes, it would be. Matter of fact, it's required by law. Would it be permissible to disclose the entire client's medical file to a care provider treating the client for a sprained ankle? Again, like we talked about right before the break, you could argue that this would be a violation of the minimum necessary rule, but in my humble opinion, if the medical provider asked for the entire file, I say give them the entire file. They know what they need to treat the individual. They are another covered entity as well, so they should be protecting the information too, so it should be fine. But again, you could make that argument, that's for sure. And then lastly, would it be permissible to disclose client PHI to a subcontractor that's providing treatment to the client? Absolutely. Not only would that be a treatment disclosure that's authorized under HIPAA, but considering they're a subcontractor, you should have a business associate agreement in place with them, and so thus it would be permissible there as well. So yeah, definitely fine on that one as well. Okay, so moving on. What is a breach under HIPAA? Give you a little second to take in the comic here. There are a wide variety of practices in place out there in the medical community. I like this comic because it kind of demonstrates that for you, that some people or some organizations have HIPAA release forms that are extremely tight. And so that comic there kind of demonstrates that for you. But I've also seen the other extreme where the medical provider doesn't seem to even know HIPAA exists. One of my medical providers here in town actually has a sign-in sheet, and I've never said anything to him about it, but that is a blatant violation of HIPAA, and I chuckle every time I walk in there and see it. But anyway, all right. So what is a breach? It's the unauthorized acquisition, access, use, or disclosure of PHI, which compromises the security or privacy of the information. That is the key right there. There are a lot of instances that have been reported to me over the years as a privacy officer that seemingly were breaches, but upon closer examination, we were able to determine that it didn't compromise the security or the privacy of the information in question, and so thus it was not a breach. You might be thinking to yourself, okay, well, give me an example of that. What would that look like? Very common in the Medicaid program that we would mess up and send information to the wrong doctor. You know, Dr. X is supposed to get the information, but we accidentally sent it to Dr. Y. Those we could write off as not breaches because Dr. Y, even though it was the wrong doctor, they're still a covered entity under HIPAA, and they thus have to protect the information as well. So that's an example of a breach that did not compromise the security or the privacy of the information. So, all right. First of all, let me point out to you that a disclosure is not necessarily a breach, okay? This is a nuance that I always pointed out to my staff at DSS because they were seemingly freaked out by the word disclosure. Anytime you said disclosure, they're like, oh, it's a disclosure. Well, not every disclosure is bad. The disclosures we're concerned with are those that you don't have an authorization for. So either you don't have the client's consent or you don't have a legal justification for them. Those are the disclosures that we're concerned about because they are unauthorized by the law and so therefore are a breach. But if you've got their consent to disclose it or you've got a legal justification for it, Disclosures are fine. Matter of fact, they're very commonplace, and it's a necessary part of doing business. So how do you disclose information? It could be a conscious act. It could be, actually handing someone a file or sending someone an email. It could be an inadvertent act, such as leaving a file on top of your car and driving off. That was something that happened at DSS a few times, and I was always amused by. And then it could be something completely beyond your control, like someone breaks into your offices and steals a bunch of information. Or it could be that they've just broke in and stole computer equipment or, office furniture or whatever, but the information was still there and thus disclosed. So disclosures can take place in a number of ways. So whenever they do occur, you got to look for those two things. Was it an authorized disclosure? And did it compromise the security of the information? So what happens whenever there is an unauthorized disclosure, or in other words, a breach? HIPAA requires that you have to notify all the affected participants as soon as possible, but in no case later than 60 days from the date of discovery. Now, a couple points to make here. I know it says you have 60 days, but you don't really, even though it says that you don't really, because the real key to a HIPAA compliance investigation is how quickly you made notification. Give you an example. We had a breach at DSS back in 2013 in which we disclosed around 30,000 people's information. Obviously reported that to the feds. They came in, did an investigation. It had taken me 57 days to make notice in that case. And the very first thing out of their mouth was, why did this take you 57 days? You should have been making notice immediately and wrapped it up within a week or two. Then I explained to them, well, when we discovered what was going on, we had to sort through 4 million computer transactions to figure out which ones were actually breaches. Once they heard that, they backed off. So you see the point that I'm trying to make here. They're all about how quickly you made notice. So if you're talking about one person's information that got disclosed, you became aware of it pretty much immediately. And if it takes you a couple weeks to make notice, they're going to hold your feet to the fire on that. They're going to ask, why did you wait 2 weeks? So they like to see you make notice as quickly as you possibly can. So always remember that. Don't sit on these things. They don't get better with time. So just make notice as quickly as you possibly can. You also need to report incidents to the Department of Health and Human Services, and you have to do that on an annual basis. The report's due at the end of February. If you go over 500 people's information's being disclosed by a single incident, you have to notify them immediately about those incidents. So the little ones and twosy breaches where you've disclosed just one person or maybe 2 or 3 people, those can all wait until the end of the year if that's what you prefer to do. But any breach that's over 500 people, you have to notify the feds immediately. My personal recommendation is you might as well just make notice to the feds immediately on each one of them. That way you don't forget about them and they don't pile up and become a huge arduous task at the end of the year. Now, if you go over 1,000 people affected, then state law kicks in and requires you to notify the Missouri Attorney General's office. There's a state statute for that, 407-1500. Trust me, I've been investigated by both, and you would think that the state authorities would be a little easier going than the feds. No, it's quite the opposite. The Missouri Attorney General's office is far harsher to deal with than the feds are. So yeah, hopefully you'll never face a breach over 1,000 people. I had to deal with it twice, and it was not pleasant either time. Business associates are also required to make notice as well. They at least have to notify the covered entity that they're dealing with about the breach, and then it's a contractual matter as to who actually notifies the affected participants. It could be the covered entity has reserved that right to themselves, or they might say, well, this is your breach, business associate, so you go and notify them. Really just kind of a comfort question. Whenever I was at DSS, I basically judged it by who I was dealing with. If it was a big, powerful company that I could trust and knew that they would do a good job of it, then I would allow them to make the notice of the breach incident. But if it was some little shop that I had no idea who they were, then I would keep that right myself, so that I would be able to do it correctly and not have to worry about it. So here's some things that are very common that you can do to avoid improper disclosure. These things happen all the time. So if you're going to be emailing people's PHI, I highly recommend that you come up with some sort of encryption system. The system that we used at the state is depicted there on the slide. I probably should have taken that out for you guys, but at the state system, if you ever get an email from a state office that has encrypt in brackets in the subject line, that's why they're encrypting the message. And but you can get all sorts of different softwares, and there are services available where you can get encryption of your email through like Barracuda and some other companies out there. So yeah, I highly recommend that if you do email confidential information, or at the bare minimum, you can have clients sign a consent form that basically informs them that email is not a secure mode of transportation or transmission of PHI, and they can opt in or out of the use of email to share their information back and forth, that sort of thing. So you can handle it either way. Don't discuss people's PHI in a manner or a location where it can easily be overheard. Again, this is a very common scenario amongst caseworkers getting together and talking and that sort of thing. And then I actually had a case once in southern Missouri. I'll leave out the town because it's an extremely small town. But basically a in-home healthcare worker after work went to the bar, started commiserating with the bartender about how she hated her job, blah, blah, blah. And then she starts whining about this guy that she'd been working with all day. Lo and behold, it turned out to be the bartender's father. And that was obviously reported to me. And yeah, talk about bad luck for that particular in-home care worker. Make sure whenever you're dealing with documents and files that contain people's PHI, make sure you leave that in some sort of secure location, no matter where you're at. So in the workplace, make sure your workplace is secure, or if you don't have a secure workplace, maybe a locked drawer, locked file cabinet, that sort of thing. Don't leave them sitting out on your desk unless you have a secure workplace. You might ask yourself, well, what about cleaning crews? That's easily handled by having a business associate agreement between them and between yourself, and the company that provides those services for you. So that's typically not a problem. And then also outside of the workplace, if you're going to take people's information in your vehicle, on an airplane, that sort of thing, make sure you've got it secured somehow, either in a locked briefcase or some sort of compartment that's locked in your vehicle. If you don't have a trunk, I highly recommend you put it in a trunk if you have one. But if you don't have a trunk because you have a van or an SUV or what have you, at least put it under the seat or something like that. Because believe it or not, there are people out there who will break into your vehicle just to steal files. And again, it's all about identity theft. They see a big stack of papers and they figure, hey, that looks official, must be some information in there. And so they will smash and grab files out of your car, especially in the bigger metro areas. You'll see that sort of thing. Same with laptops and smartphones, that sort of thing. Make sure they're password protected and that you lock them up whenever they're not in use. And what I mean by that, I don't mean lock them in a cabinet or something. I mean the screen is locked so that other people can't get into it. Dispose of documents that contain confidential information in locked shred bins, such that they're not disclosed to anyone besides the company that provides the shredding services for you. And then last but not least, the most common breach that we had at DSS was mismailing. So just make sure you're putting the right stuff in the right envelope so that it's getting to the right people. Okay, penalties for compliance. There are civil penalties and criminal penalties. The penalties are in both instances are basically set up the same way. You have 3 tiers based on the egregiousness of the event. So when it comes to the civil penalties, $100 fine for the least severe, and as you can see, you can go all the way up to $50,000. But think about how many penalties can be racked up by one piece of paper, or you know, probably the most dangerous thing in the world is an Excel spreadsheet, because the way the penalties work is it is per piece of information. So imagine an Excel spreadsheet. You can literally have hundreds, maybe even thousands of pieces of information on an Excel spreadsheet. And even at $100 a pop, that's going to add up really, really quickly. So yeah, the civil penalties are very significant and definitely something to keep in mind. Criminal penalties, again, it's a three-tiered system. You have fines and possible imprisonment. The only imprisonment I've ever seen under HIPAA has always been tied to identity theft or some sort of fraud activity. So, you know, if it's an honest mistake, you just mismailed something, you left a file out, that sort of thing, you're not going to prison for that, so don't worry about it. But if you're defrauding the government or stealing people's identity, chances are you are going to go to prison for that one. So, you know. All right, little pop quiz for you. I'll skip past and give you all a chance to answer. This is the poll out. Yeah, there we go, going out. Okay, whenever you want to turn it back over to me, we'll go through the questions. Hey, I'm back. Boom. All right, back up here. Okay. Question one, you got the worker who leaves a report with patient names on the roof of her car and drives away. The report is subsequently found by a Good Samaritan and returned intact to the worker's office. That is a breach, definitely. And the reason why I made this into a question is because how adamantly the worker fought me on this, because they kept pointing to the fact that it was returned intact. And so they're like, oh, it came back intact, everything's there, so it can't be a breach. And I was like, how did it come back? They had to have at least looked at it to figure out where it came from. And so, of course, it's a breach. So yeah, absolutely, that is a breach, even if it does come back intact. Okay, number two, Joan accesses the information of her employer's database to find out information on her relatives, just out of curiosity. Yes, that is absolutely a breach. And you know, every organization's different, but I can tell you the organizations I've worked at, that's something that will get you fired in a hurry. So I highly recommend that you not get curious and start digging around in your employer's database. Okay, number 3, Brian accidentally places a letter to a participant into an envelope addressed to a different client. Absolutely, that is a breach that, like I said, was probably our most common breach at DSS. Happens all the time. So slow down when you're doing your mailings. Make sure that you're getting stuff into the right envelope. And then number 4 there, John accidentally mails a letter to the incorrect address for a client. Is that a breach? Maybe. That all depends on whose fault it is. If the client has not updated their information with you and you send the letter to the last known address, that's not your fault, and so therefore it's not a breach. However, if they have updated the address with you and you use an old address, that becomes a breach. So that's what was the case with our big breach there at DSS that I mentioned earlier, or 30,000 people. Our electronic systems maintained record of previous addresses. And so basically the system broke down, and whenever people were calling in to update their addresses with us, the system was still using the old address, even though we had the new address in the system. And so, yeah, that's why we had a breach there. Okay, participant rights under HIPAA. People have the right to access their PHI that you maintain a record of, and I don't know if this happens in the private sector as frequently as it does in the state government, but in state government this happens a lot. People will write in and make a request for a copy of all the PHI that you have on them. Happens all the time, and you do have to give it to them. They have the right to designate anyone they choose to be their personal representative, to act on their behalf and to receive their information. And HIPAA does not allow you to question their judgment, by the way. There is one little minor exception to that rule. They do allow you to basically ignore request whenever you suspect that they are the product of duress or some sort of abuse type of situation. But you've got to have pretty good evidence of that. It can't be just a mere suspicion of it. So yeah, that's the only exception to that. But yeah, they can literally pick a stranger on the street as their personal representative, and you have to respect that decision. Same with authorizing disclosures. They can authorize the disclosure of their information to literally anybody that they want to. And again, if there's no evidence of abuse going on there, you've got to respect that. And then finally, they do have a right to an accounting of their disclosures. And what that means is you basically have to tell them everybody you've shared their PHI with for the last 6 years. Now, it's not everybody. The rule does give you a number of exceptions that you don't have to keep track of. And most of the payment and treatment and healthcare operations disclosures are going to fit into those exceptions. So it's really, my analysis of the rule is it really boils down to breaches. You have to tell them about any breach. And then you have to also tell them about like litigation demands, or people who have written in and asked for their records, that sort of thing. So it's fairly rare. That usually the list of disclosures is not that big for most people. Oh, research is another one. May not come up for you guys in the private sector so much, but in state government, that comes up a lot. We get a lot of requests from professors and universities wanting to do research, especially in the Medicaid program, as you might suspect. Okay, that's HIPAA by itself. Like I used to always tell my old boss at DSS all the time, HIPAA, once you get to know it, is really pretty simple. Here's where your real headaches come. It's all the other confidentiality laws. So once you get past HIPAA, that's not the final hurdle. Then you got to worry about all of this. Yeah. Like I said, the point of me showing you all that stuff is not to impress upon you you know, all those different laws and what they require and all that. Obviously, we're not going to go through all that stuff. My point is, like the slide says here, everything in your file is probably confidential under something. So my advice is keep all that stuff protected, keep it confidential, only share it with the client's consent, or if you have some sort of legal justification for it. Otherwise, I wouldn't be sharing people's information with anything, with anybody. So, okay, let's talk about a few in particular. Missouri has its own little version of HIPAA. It's called 407-1500. I touched on it a little bit earlier. The big difference here is, by the way, it does have all the same breach notification rules and all that stuff, just like HIPAA does. But the big difference here is this covers what they call personal information. And the way they define personal information includes unique identifying numbers that are collected or created by government agencies. And if you think about it, wow, that is pretty much everything. You know, phone numbers would fit into that, social security numbers, DCNs if you're dealing with the Department of Social Services or some of the other state agencies. Any, like I said, pretty much any identifying number is going to be protected by this law. And so, yeah, like I said, it works just like HIPAA. And in terms of breach notification, all that sort of thing. Again, if you go over 1,000 people, it does require you to notify the Attorney General's office as well as the nation's major credit reporting agencies. Then you have Medicaid medical assistance program laws set forth in federal statute and in federal regulations. Basically, the way these rules break down is disclosures of this information can only be in furtherance of administration of the Medicaid program or Medicare program, whichever one you're dealing with. So again, this stuff is very tightly regulated as well. It's basically public assistance information. Speaking of public assistance information, it is specifically protected by state and federal law as well. And again, it's limited to only for purposes associated with the administration of the program. So again, very tightly regulated stuff here. Substance abuse information is extremely tightly regulated. It's probably the tightest information out there in terms of the tightest regulations. I mean, basically, the way to summarize these next few slides, I'll just kind of flip through them really quickly for you. The best policy to have in place when it comes to substance abuse information is only share it either pursuant to a court order or with the consent of the individual that it pertains to. So get their consent, get a court order, otherwise you don't share it with anybody. Okay, sharing information with healthcare providers, again, that is completely fine. It's going to be fine under HIPAA because it's probably for treatment purposes or payment purposes, one of the two. You may or may not have a business associating agreement in place, but yeah, it's really not necessary. It's certainly not wrong to do it, but yes, this should be absolutely fine. And last, but certainly not least, allow me to give you a little plug on my organization, the Missouri Veterans Commission. I just wanted to throw this in at the very end because I know, considering the clientele that you're working with, you probably come into contact with veterans a lot. And so I just wanted to point out to you that we do operate 7 veterans homes throughout the state. We do have 5 veteran cemeteries throughout the state, and we have veteran service officers available throughout the state. So if any of your clients or their family members are former military, they've served in the military, please encourage them to come in and see one of our veteran service officers, and let's see if they're eligible for any VA benefits. Most of them are, and you know, obviously, it can be very financially beneficial to them to come see us. So please encourage them to do so. You can go online and just Google Missouri Veterans Commission and go to our website and find out where our veteran service officers are located. But basically, we have satellite offices in pretty much every county seat throughout the state. So it should be an easy commute for pretty much anyone. So with that, thank you very much for allowing me to throw in a little plug there about my my current employer. I will open it up to questions.
So Scotty, this is Catherine. We may be having an issue with people entering questions in the chat box.
Okay.
We did have a couple of, we opened the question box back up and there were a couple of comments. Trying to. One person was talking about our quiz questions, that they weren't quite exactly like the original versions that you were discussing at the end. And we should just let everyone know that we were limited in our number of text or number of characters that we could include in the question. So we apologize if they were not exactly the same.
Yeah. Tried to edit those down as best as we could.
So Erica, if you'd like to jump in and look at the question box, feel free. Or Scotty, if you want to open it up.
I'm sorry, this is Erica. I'm looking, I don't see any questions in the chat.
Not in the chat, but there's now a question box.
Oh.
Since it wasn't working, I opened the question box up and now it looks like we have several.
I got it. Okay.
You want to take that? Okay.
Sure. I can help you or.
Yeah, feel free.
Okay. Okay, so let me see here. How do we open this? Okay, so the first comment was about the last quiz question, but I think we kind of we addressed that. We have a question regarding typing encrypt in the subject line. There was a comment that it does not necessarily encrypt your emails. I wanted to know if you could comment on that.
Yeah, that was, I'm sorry, I should have taken that out of the slide. That was left over from whenever I would train DSS personnel. That's the way the state system works. And so, yeah, I should have taken that out because it really only applies to them. However, I guess it is beneficial to point out that if you ever do receive an email from a state office that has encrypt in brackets in the subject line, it will be encrypted and you'll have to go through the unlocking procedure to get to that message. So yeah, I apologize. That was really just for the state system.
Okay. We have a question about how is the quiz going to be graded, because the speaker's not giving definitive correct answers, or there's no select all answer. So I think we'll be flexible in our scoring. If there was ambiguity, if it could be or couldn't be, if there was sort of qualifications around it, we'll mark it as yes. If you got one correct answer, we'll consider that a yes, and we'll just be flexible there and just kind of make track that everybody participated and was kind of online through the whole webinar, and so we'll be flexible about that.
Yeah, and the reason why I selected some of the questions that I did is to demonstrate the complexity of some of these seemingly simple concepts.
The next was when being asked for. Okay, yeah, I think we had a couple questions about this, kind of how they can only select one answer. There are ambiguities in the answer. So I think we answered that. It seems like the definition of PHI almost depends on how the info is disclosed. Is that right?
No, I wouldn't think so. I'm trying to figure out where they were coming from with that. So that's why I'm pausing. I'm not sure what I said that might lead someone to that conclusion. Now I will say this: PHI is. Yeah, I think I know where they're coming from. Yeah, PHI would only be a breach under HIPAA if it was disclosed by a covered entity. So let's say that an individual came across health information just in their personal life, and then turned around and shared that to somebody else. Well, that person is not a covered entity, and so therefore it's not a breach under HIPAA, even though it would be a breach if the covered entity disclosed the exact same information. So yeah, you're correct in that it really does all depend on who is disclosing it. That is for sure.
Okay. How does HIPAA work in hospitals and sharing of rooms with individuals you do not know?
Yeah, exactly. That's a very good question. First of all, I'll point out to you that a lot of medical providers like hospitals and our veterans homes are moving to single occupancy rooms for just this very reason, to give people their privacy back. But probably the way it is working is whenever you're admitted to the hospital, somewhere in those admission forms, I bet you're signing a consent form saying that it's okay for your roommate and others to be exposed to your personal health information.
Okay. As a contract assessor, is it safe to call health home agencies to gather alternate information for participants, I think?
Yeah, I would think so. I would think that that would all be pursuant to a treatment function. So I would think that would be completely fine.
Okay, and so as a follow-up question, so would they need to have some sort of contractual arrangement between the two of them to be able to talk and share that information? Or would it depend?
Well, I'm just a little confused. Wouldn't they have a relationship, or do you guys come? I was assuming that they did have a relationship.
Okay. Who answered that? Whoever asked that question? If you want to, if my follow-up question was confusing, please clarify. Is this a health home agency that you worked for? Okay, here it is. The health home agencies are contracted by DHSS. Oh, so they should be fine. Okay, I got it.
Yeah.
Okay.
Yeah. I know the scenario that you're talking about. That is a very weird relationship because you're right. They are contracted by DHSS, but then they're regulated by DSSS, or actually no, they're paid by DSSS. That's right. And so yeah, I got a lot of their breaches reported to me, and for years I was like, why are you sending me this stuff?
Okay. Is there a reason to document when giving out information?
You know, you're certainly never wrong. And it's, you know, it's a good way to keep track of who you've shared with and why, so that you can go back and analyze your practices and make sure that you know, that you're handling your disclosures properly. It also would help you in the event that you get a request for accounting as well. From a public relations standpoint, you could also say, I suspect that most people would appreciate you being able to thoroughly lay out, hey, I shared with these people on these dates for these purposes. But in terms of a legal requirement, the only legal requirement would be the accounting requirements. And again, that's limited to pretty select few types of disclosures.
Okay. Someone asked on the final quiz question, was the correct answer number 4?
On the final,
What were the correct answers?
oh, for the last
final one, the final quiz, yeah.
Yeah, let me get myself in, or get them in front of me. Question number 1 was about the leaving the file on top of the car and driving away. Yes, that is a breach. Number 2, accessing the employer's database out of curiosity on your family members. Yep, that is a breach. Number 3, the employee mailing information to the wrong person, basically stuffing an envelope. Yes, that is a breach. And then number 4, the answer there is it might be a breach. It depends on whose fault it is. What happened in question 4 is the worker accidentally mails information to the incorrect address, and the distinction here is whose fault is that. If the client has failed to update you as to their current mailing address, then that's not a breach because it's not your fault. You didn't know what their new address was. But if they told you what their new address was and you still sent it to their previous address, then it is a breach because that becomes your fault.
Okay, so we can be flexible and accept any of those answers. If someone talks privately to someone about, okay, if one talks privately to someone about someone with COVID, is this a breach?
Could be, depends. I'm assuming, if you're talking about yourself having COVID, then no, that's not a breach, obviously, because you're consenting to the disclosure of your own information. But if you're talking about a friend or a relative or somebody else, a mutual acquaintance that you both have that has COVID, yeah, that would be a breach of their information if you are a covered entity again. If you're not a covered entity, you're just doing that in your personal capacity, then no.
Another comment about we can only select one answer, so we'll count any of the answers that were correct. Impermissible disclosure question should have all been marked, but that was the one you couldn't select all. So was that number 4 and all? Impermissible disclosure questions. Should all of them have been marked? But
Should all of them have been marked?
yeah, the quiz question, I'm assuming this is about the impermissible disclosures. Was there a quiz?
Well, question number 4 was the one where
Yeah.
Yeah,
So we will accept any of them.
right, yeah. It could have been a breach depending on whose fault it was.
Yeah. There are times that patients ask me to send in an application to an entity like FSD. Do I need to get a release of information from the patient rather than just using their verbal request to submit their application for them?
No, I wouldn't think so. Yeah.
You don't need to wait for consent or release of information. Okay.
Right. Yeah.
Why is a record number unique to a specific system? Why would a record number unique to a specific system be PHI?
Because they can take that information and potentially tie it to other pieces of information and then figure out other information. Yeah, they can basically use it as the key to gain access to other information.
Okay. There are some questions about wanting clarification on what I need to consider when looking at providing telehealth services to our clients.
Yeah, great question, very timely, given the circumstances. We personally at the Veterans Commission here recently really ramped up our telehealth operations as well because of all of this. And really, you basically just need an informed consent form that clearly sets forth to the client what you're doing, what the risks are, and then just get their consent that I acknowledge what the risks are and I want to participate.
Does the health department, go ahead.
I was going to say that doesn't have to be anything fancy either, by the way. Ours is a one pager, and yeah, it doesn't have to be anything complex.
Okay. Does the health department have the right to call for PHI when investigating cases without consent of the patient?
Yes, they do. Yeah, that is permissible under 45 CFR 164.512. Paragraph B, to be exact.
Okay. Can you expand on the proper way to encrypt emails if you are not DHSS? They run into this a lot.
Yeah, there are a number of softwares available online. I would just, Google encryption software and just pick a product, whichever one, suits your business needs and, is satisfactory to you in terms of price and that sort of thing. I not a plug for them specifically, but one example is Barracuda. I have heard good things about that company. I'm sure there are others out there as well, though. But yeah, you basically just get the software and then, it will encrypt your emails for you.
Okay.
Or, like I said during the presentation, let me point out that there is an alternative to that. You don't necessarily have to encrypt your email. What you could do is just get signed consents from everybody that you're going to be emailing their information, and basically just get them to acknowledge that email is not a secure mode of transmission and that they're comfortable with you doing it. Once you get their consent, you're fine. You don't necessarily even need to encrypt if you go that route.
Okay. That's helpful. I have a follow-up to the record number question. He said, I should have said, why is an account number unique to a specific internal system be considered PHI?
Yeah, because they can take that piece of information and trace it back to an individual.
As far as the file on the top of the car, do we need to show intent to breach?
No, the intent's completely irrelevant. So yeah, the mere fact that it was an accident doesn't matter. It's still a breach. Let me tell you a little horror story really quick. The way I came into contact with you all, by the way, was a director of an area aging agency, pardon me, in the St. Louis area, reached out to me just because they found me online, and they basically said, hey, our offices got broken into last night. Is that a problem for us? And I was like, oh yeah, that is a problem for you guys. Even though it was not their fault, that's still a breach, because they sent me pictures of what the crime scene looked like, and it was pretty clear that people had gone through their file cabinets, probably looking for electronic devices or other things of value. But the mere fact that they opened those cabinets and the files were, kind of hanging out, and some of them were on the floor, that sort of thing, it's pretty clear that somebody touched those files, and you can't write off the fact that, you can't just assume that they weren't looked at. And so you have to call that a breach, even though it wasn't your fault at all. By the way, when it comes to enforcement, the feds and the AG's office, they're going to keep all that in mind, by the way. If it's a crime that somebody broke into your offices, don't worry, they're not going to rake you over the coals over it, but you do still have to report it.
Okay. That's helpful. Does consent expire, or does it have to be revoked?
Good question. Under the law, it says consents are good for 2 years. My personal advice at DSS, I always said we're not going to rely on a consent that's over a year. And the reason for that is, things change. They might have consented to disclosing to this person a year ago, and now they hate each other. And so, it saves you a lot of trouble if you require it to be within a year.
Okay. I think we have another question here. It says, didn't the last question on the screen use the term disclosure instead of a breach? On one of the slides, it states a disclosure is not necessarily a breach. How does that affect the last selection on the last question?
Well, the last question of the pop quizzes, is that what you're referring to?
I believe so.
Oh, well, if you look at the slide, it says, is it an improper disclosure?
Mm-hmm.
And like we talked about, not every disclosure is a breach, but improper disclosures or unauthorized disclosures would be breaches.
Would be breaches. Okay. If that didn't answer your question, you can type a follow-up in the box. Oh, we have another follow-up to the record number. It says, how can someone use a record number to access other information if they don't have access to the system that ties that record number to the other information?
You'd be amazed at what identity thieves can do. They can piece together all sorts of little things, and access information that you would never imagine that they can do.
Okay. Would you be willing to share your informed consent language for telehealth?
Oh yeah, sure.
Okay. We
Yeah,
can
but
send.
I was going to say, I think my next slide, don't I have my contact information up here? No. Well, wouldn't it? Well, shoot. I'm sorry, folks. You guys have my contact information, right?
I have it. Yep. We can,
Okay, yeah. If you want to just funnel those questions, those types of requests or what have you, I'd be happy to share that.
okay. I could, would you want me, I can type would you want me to put your email into the question box? Or
Sure.
just, okay.
Yeah, that'd be fine.
Okay. While I do that, does anyone have any other questions?
By the way, folks, you can reach me through
yeah.
our website too, by the way, and I'm always happy to help. If you got a question or scenario comes up, that sort of thing.
Okay. We have a follow-up question. Can you please explain the difference between a disclosure and a breach?
Yes, a disclosure. You basically have two types of disclosures. You have authorized disclosures and unauthorized disclosures. An authorized disclosure is completely fine because you have the person's consent or you have a legal justification for the disclosure. So those are completely fine. Unauthorized disclosures are the ones that are breaches. And that's because you don't have the person's consent and there's no legal justification for the disclosure. So that's what makes it a breach.
Okay. Let me see if I got any other questions. I think that was the last. Does anyone have any final questions? I'm gonna pull up the chat box and paste in your contact info. But I think that is, though that was, I have not gotten any other questions. Oh,
Okay.
I have one more. Got one. Is a law firm helping a client with a Medicaid application considered a covered entity?
No, the law firm would not be. They are probably acting as a legal representative for the individual under HIPAA, or they might even actually have a disclosure agreement in place between them and the client. I've seen law firms work both ways, but yeah, they are the authorized representatives in some capacity for that individual.
Okay. That was our last question.
Okay.
Yeah, if there aren't any more questions, I thank you so much for your time.
Yeah.
This has been really helpful and informative for us. We will work with Scotty to maybe plan another one in the fall. And if you have feedback information, please feel free to share it with me. And so I thank you, Scotty, so much. Do you have any final words or?
No.
Okay.
Thank you very much for your time. I appreciate it.